President, dear colleagues, I thank the rapporteur for tabling an interesting memorandum and for drawing up a clear resolution in front of us. The members of our group fully share the commitment of this Assembly to fight against impunity for perpetrators of serious human rights violations and against serious forms of corruption that undermine the rule of law. However, most members of our group have serious doubts as to whether the draft resolution on the table is the right way to implement this commitment. The first reservation concerns the fact that the resolution unfortunately mixes up two partly separate issues: the specific case of the death of Sergei Magnitskyi and the call to member states to introduce generic legislation. This, in our understanding, is not really due process. As for the specifics of the Magnitskyi case, indeed, earlier calls to provide more transparency on the case have unfortunately been met with characteristically uncooperative Russian responses. Resolution 1966 has addressed this and called for follow-up by competent authorities, and that has resulted in some member states and some other states adopting national Magnitsky acts in various forms. However, as the memorandum by the rapporteur rightly acknowledges, the circumstances and the background of Magnitsky's death have so far not been fully and satisfactorily investigated. A 2016 documentary by the Russian filmer Andrei Nekrasov, possibly throwing new light on the background to the case, has been so effectively banned from public access in the West that someone like me earlier today, trying to locate and access this documentary on the internet, might well think that he or she has ended up in China. This brings us to the issue of legal safeguards, dealt with in Chapter 4 of the memorandum. This states that PACE Resolution 1597 of 2008 on the UN Security Council and EU blacklists is followed in this resolution. Unfortunately, that is not quite the case. In the current resolution before us, paragraph 11.2, these safeguards are watered down to be notified promptly and fully informed has become are informed of the imposition of sanctions and of the full and specific reasons for their imposition. The original right to be heard has become the right to respond. The independent, impartial review body has become an appeals body that enjoys sufficient independence. Compensation for any violations of rights has become adequate compensation in case of erroneous sanctions. It's almost the same, but not quite. The devil is in the details. What is striking, furthermore, is the lack of serious legal analysis in the memorandum. Both of the legal principles involved here, for example, the presumption of innocence until proven guilty by an independent court, and of the actual practice in those countries where a Magnitsky Act has been adopted and where, with the possible exception of the UK, no provision for proper judicial review is included, nor a time limitation as also required by Resolution 1597. In conclusion, while we cannot support the resolution on the table, we would welcome in the near future the commissioning of a new report to make an inventory of existing issues regarding targeted sanctions. Such a new report could also look in more detail into the place of the International Criminal Court in this context, and give more detailed attention to the possible role of NGOs in maintaining documentary databases, as is suggested in paragraph 35 of the memorandum. Thank you.
Je profite de vous rappeler qu'il reste 5 minutes pour le scrutin pour l'élection de juges à la Cour européenne des droits de l'homme. Donc celles et ceux qui ne l'ont pas encore fait peuvent profiter des 5 dernières minutes. La parole est maintenant à M. Kandelaki pour le groupe PPE.